Okay, so now we're down to Patent Law Week 3, Lecture 3, the last lecture for this reading material. And again, we're covering the non-obviousness requirement. And so we looked at KSR versus Teleflex, where the court held that the patented issue for a new pedal assembly for an electronic fuel injection car was obvious, which is a combination of prior art elements doing exactly what we expected them to do based upon their roles in the prior art. Today, we're going to continue our discussion about that. And so we start with, again, the changes to the non-obviousness doctrine brought by the Federal Circuit. It was created to oversee patent litigation in 1982. So we still have the same trial courts trying the cases, the federal trial courts, federal district courts. But now when those cases are appealed, they go not to the regional circuit, the first, second, third, fourth, fifth, etc. So they all go to the federal circuit. Now we still have the Supreme Court above the federal circuit, as we did in the old era as well, above the regional circuits back then, now above the federal circuit, on patents at least. And so federal circuit is not the final word, but the Supreme Court only gets involved every 5 to 10 years, or on occasion when it thinks things have gotten really out of hand. So for the most part, the Federal Circuit is the final word on patents. Not entirely, but at least that's how they view themselves. And they brought this perspective of patents not as monopoly, but as simply property to patent law, and really radically changed a number of areas of law, including what we're focused on right now, the non-obviousness doctrine. Instead of sort of reserving patents only for truly deserving inventions, substantial advances, sort of thought that patents were deserved even by small advances. Now, maybe you get a small patent scope, but you still get a small patent. And to accomplish that result, brought 3 doctrinal changes to the analysis of the Section 1 and 3, or of the non-obviousness inquiry. First, in order to combine prior art references, requires a teaching, suggestion, or motivation. Now, you might think that the court did away with that. Supreme Court did away with that, as it said expressly in KSR versus Teleflex, but it remains part of the doctrine even today. And panels of the Federal Circuit still go on their way and say, well, there's no teaching, suggestion, or motivation, so it's not obvious. They elevated the secondary considerations as their second change to objective evidence of non-obviousness, not just a tiebreaker, but always must be considered. And third, relentlessly enforce the presumption of validity, even with respect to prior art that the examiner did not have before him or her when they issued the patent. And now today we're going to focus on the secondary considerations, or as the Federal Circuit likes to call them, the objective evidence of non-obviousness. And so in Graham versus John Deere, the court listed 3 of those and a little et cetera at the end: commercial success, long felt but unsolved needs, and failures of others. Now, our fit here with our policy concern of only giving patents to those inventions that need that additional inducement the patent provides is that these can provide sort of circumstantial evidence or direct evidence that the invention was not an easy or trivial invention, but it was in fact difficult or hard and therefore needs that additional inducement. Now, some of these secondary considerations provide a better evidentiary basis for inferring that we need a patent here than others. Commercial success on its own, for example, is probably the weakest of the secondary considerations in terms of showing that we need a patent here to bring this forth. There are lots of commercially successful products that don't have a patent on them at all, like the quarter pounder with cheese that McDonald's sells, or Pet Rocks, or Beanie Babies, right? We've had any number of successful products, fads, or even continuing success on products that were not patented at all. So commercial success does not always suggest, and does not even usually suggest, that you need the extra protection of a patent on the one side. Moreover, on the other side, only commercially successful inventions are litigated, right? If there's no money at stake, if no one's making no money because the invention was a failure in the marketplace, no one's going to sue for patent infringement. It's just money down the drain, pouring good money after bad. So if we really sort of followed this secondary consideration, said, well, evidence of commercial success proves non-obviousness, it would lead to the conclusion that all litigated patents are non-obvious because only commercially successful patents are litigated. And that's obviously not the right answer. And so some of these secondary considerations are stronger circumstantial proof of non-obviousness than others, and some are not very strong proof at all, and they really shouldn't be included in the list. But because we've included them once upon a time, we still have to include them today. So the casebook breaks these down into, there's a much longer list than just the three the court gave us in Graham versus John Deere. You saw that little etc. So there are sort of technical considerations or aspects of the art or things in the art that sort of weigh in favor of non-obviousness. Teaching away means that the state of art in the technology field taught away from the solution. Don't do this, don't try that. Bad things will happen. If you put magnesium in water, there's going to be an explosion, very vigorous explosions. Don't try a magnesium battery. Don't use that as your electrode in a water-based battery. Unexpected results. So here's sort of a version of the synergism test, though a little bit watered down. Don't need a synergistic or truly unexpected result, but something that's just unexpected in a more mild way. It's a problem that others have tried to solve and have failed. And we need to be a little careful of this one because sometimes there's advances in sort of associated technology. And I've been trying to solve my problem, computer-controlled electronic factory, and it's not going to get there until the chips get there and are fast enough. And so it's not my invention that makes it work. It's really that the chips finally get to the point where such a control system would be possible. But if the technology doesn't change outside the field in that way, and it's just everybody's been trying to solve this problem, you see a new way to do it, that would be evidence of non-obviousness. Skepticism that your results actually work, even when you show they work, they want to test it for themselves, would be evidence that it's a difficult or hard or unexpected invention, therefore non-obvious. Professional approval, awards, Nobel Prizes, perhaps that's not usually given for engineering or real-world solutions, more for theoretical solutions, but some sort of professional approval of the technical merits of your work would suggest non-obviousness. The last one here on the list actually cuts the other direction, or at least sometimes it does. If 3 or 4 or 5 people near simultaneously solve the same problem with the same solution, that suggests it was sort of more a skilled workman, the work of skilled workman rather than an inventor, and sort of not that difficult. Of course, Isaac Newton and Leibniz came up with calculus at about the same time. That I don't really think that this always proves that it was an easy thing to do, because coming up with calculus based at the time they did, based on what had gone before in math, was obviously, maybe not obviously, but non-obvious advance. So not always proof, but relevant evidence. Commercial considerations as opposed to technical considerations. So a long felt need. So if there's been a market demand for this solution for a very long time, that suggests that people would want to solve it to earn the money that the long felt pent up need for the solution would give. If other people copy your invention, that suggests again that it's a difficult problem. And once you came up with a solution, oh, that's a solution, everybody copies it. Commercial success, as I said, this is a dangerous and overall weak inference, and dangerous in the sense that it would mean all litigated patents are non-obvious. If people choose to license rather than litigate, though keep in mind with the very high expense of litigating patent infringement, often $50,000 or $100,000 licensing fee is much cheaper than trying to prove invalidity. So it would depend on the nature of the licenses. And then, as we saw last time, sometimes it's not your advance, really. You're just putting together advances in collateral technology. And that's really what Teleflex Engelgau was doing in the KSR case. They didn't invent the sensor. They didn't invent the pedal assembly. They didn't invent the digital cable. They were just copying and putting together advances that other people were making in those associated fields. So that brings us to the case Apple versus Samsung, and whether a patent on the iPhone's feature where you slide to unlock the screen is patentable. And obviously the problem we're dealing here as we move to smartphones as opposed to flip phones is pocket dialing, right? If your phone is just a face, any contact with that face may cause certain things to happen, such as you make a pocket dial phone call. And so we need some feature, some that you can, some mechanism, some push or control features that we can use to unlock the phone so it doesn't dial when it's locked and then it does when it's unlocked. And so the prior art here is a NeoNode, which you push the power button and slide to unlock, and the Plaisant for wall-mounted air conditioning units with their various unlocking mechanisms, including the slide to unlock feature. And so Apple concedes it's a little hard to see why this is not just a straightforward novelty issue. The NeoNode seems to have all the elements and more of the patented invention, but instead we're dealing with it under obviousness. And Apple concedes that the two together describe all elements of Apple's patents. So they're all out there in the prior art. Apple's just put them together on the iPhone. Is that enough to get you a patentable invention? Now, I would think the answer here would be no, based upon KSR versus Teleflex, but keep in mind that's what Supreme Court said. And although the Federal Circuit's a lower court supposed to follow what the Supreme Court said, all they're technically bound by is the literal holding of the case, the very precise ruling that for this pedal assembly, the combination of these elements is obvious. Doesn't mean you have to extend it or apply it broadly. Just if that exact fact pattern came up again, you would have to apply it. So the Federal Circuit has given a token notch and moved a little ways towards what KSR was asking for, raise that non-obvious standard, but has not really made it back into the hurdle it once was. And so we see that very clearly here in the Apple versus Samsung case. And so a little bit of procedural background here. Right, we get the trial in the federal district court, then we get a panel appeal. So when you initially appeal to the appellate court, the Federal Circuit, you get a panel of 3 judges randomly assigned from all the active and senior members of the Federal Circuit. And you can appeal to the Supreme Court from that panel, but your first route when you're disappointed with what the panel says is you file for a rehearing with the panel. You say, hey, you didn't consider this argument. You got these points wrong. Those are almost never granted. And you can ask for rehearing in bank, right? This is just 3 of 15 to 20 Federal Circuit judges, depending on the time. Maybe these 3 have an unusual or idiosyncratic view of this area of law, and maybe the remaining 12 or 15 Federal Circuit judges would see it differently. So you ask for an in-bank review with all the active judges of the Federal Circuit hearing your appeal. And that's what they did here in this case. So the panel said it was obvious. The jury had said not obvious. The panel said obvious. And here we have an in-bank appeal. So we're getting all the active judges deciding by majority vote whether it's going to affirm the trial court, the jury's verdict, or reverse it. And so we've got a number of issues going on there, right? So that's an unusual thing to happen. Very rarely, you always ask for rehearings in bank if you lose, but you rarely get them. You always petition the Supreme Court to grant review, certiorari review when you lose at the appellate court. If it's worth enough and you think you have a good enough argument, then rarely granted. In addition, right, we've got this appeal versus trial dynamic. And so in litigation, we have factual issues. Did John shoot Joe? And then we have legal issues. If he did, what state of mind is required to show first-degree murder, second-degree murder, manslaughter, and so on. So those are legal issues defined by the court. And so the trial, the jury is supposed to resolve factual issues, disputed questions of fact. It's not up to the jury to decide legal questions. They don't get to decide what the law is. That's for the court to decide. And so obviousness is ordinarily a legal issue for the court to decide on a set of facts, but sometimes the facts are disputed. Would a person having ordinary skill in the art have taught against this particular combination of elements? And so a little trouble here with whether we're going to defer to the jury, which is what the majority decides to do. And so we're going to say this is a factual issue for the jury. They found the patent not proven invalid, largely based on the objective evidence of non-obvious, the secondary considerations. And so the appellate court here is going to defer to the jury and ask not whether the appellate court itself would say, yes, this is non-obvious on its own, but whether the jury had substantial evidence and was not clearly erroneous in finding that the patent was not proven invalid or not proven obvious. We get a couple of issues with Blazon, right? The court suggests that it teaches against the slide to unlock feature. It was the 5th most popular of 6 possibilities. Not really taking that to mean that it doesn't work. United States versus Adams is a better example of teaching against, where people thought that magnesium and water put together in a battery would equal explosion rather than mild exothermic reaction with good electricity generation. So that's a better example of teaches against. But here the court sort of stretches it and says, well, the consumers didn't really like the slide to unlock and the wall-mounted air conditioner control units. I'm not really sure that's teaching against, that it's less popular than some other options. Court also raises the issue we talked about with the shuttle engine versus the sword making technique. Is this really an analogous art? It's solving the same problem engineering wise or from a scientific perspective. Analogous art really only reaches those things a person of ordinary skill in the art of cell phones, smartphones would look to solve the problem before them. So would you look to wall-mounted air conditioning control units to solve the problem for the iPhone? The court's a little skeptical of that as well. And we also have industry praise, copying, commercial success. Now, to strengthen the inference from commercial success to, oh, this is non-obvious, the courts have imposed a nexus requirement. You have to show a nexus between the invention and success. So the court sort of, but it's a fairly weak requirement as we see here, right? Is the real reason the iPhone was successful because of the slide to unlock feature? I don't think so, right? It was successful because it was the iPhone. It was a combination of a lot of features. Maybe slide to unlock played some role in it, but it's easy to imagine lots of other sort of unlocking features that could have worked just as well. And indeed, over the years, Apple's tried others, such as the facial recognition, the eyeball scan, various other things, fingerprint, passcode, right? There are lots of ways you can slide to, you can unlock a cell phone these days. So I'm not really sure I'm persuaded that there was a true nexus here, but the court at least glosses over and walks through that requirement, very superficial fashion, which is often what you get. Copying here is true, but it's unclear whether it's copying because it's a great innovation or because it's an industry standard, right? All keyboards for computers and typewriters have the same keyboard layout for the most part. It's not because it's the most efficient or a great solution. It was actually developed in the 19th century to slow typists down so you wouldn't get mechanical jamming of the keys. So we put the keys that are often typed together at different places on the keyboard to slow typists down. And that led to what's called the QWERTY keyboard layout, because the top row of 3 is QWERTY in a row. So the QWERTY key layout. But people copied it because it became the industry standard. It became what people expect. And so once iPhone did slide to unlock, that's what cell phone, smartphone users came to expect. So not really sure that copying provides much circumstantial evidence here. As for the long felt need, I mean, the unlocking features came along very quickly once the smartphones with the plain glass face and the problem of pocket dialing became obvious. So I'm not really sure long felt need here, what, 2 years, 3 years, maybe at most. That's not exactly long felt. But again, the court is saying all we need is substantial evidence. We're deferring to the jury's verdict on these issues. Very unusual for the Federal Circuit. Usually they're usurping the jury's role willy-nilly whenever they disagree with the jury's outcome. But here they're deferring to it. So you see the court walking through these factors and very little evidence, though, that persuades me that this was a difficult technical problem to solve. I mean, how much research and development, how much lab time, how many sessions were devoted to how can we solve this problem? What's the best way? Probably not that much in terms of research and development. It's not like a pharmaceutical drug where you have to go through various stages of FDA trials in order to get the drug on the market for treating a particular condition. That's a true investment of R&D, probably does need a patent system to encourage it. So again, right, it's all of the active judges on the Federal Circuit, including any senior judges that were members of the initial panel decision. So that might be 12, 15 judges. The rule is the majority controls. If you got 15 judges and 8 of them vote one way, That is the holding of the court and the ruling of the court, just as in democracy more broadly. Some judges will write concurrence where they'll agree with the outcome of the court, the majority of the court, but have different reasoning or concerned about some of the words or language the majority court uses, the majority opinion uses, want to clarify certain issues. But you can also get dissents, and we have one here. They sort of poke holes in the majority's case and explain why the majority is wrong and watering down the combination patent rules the court gave us in KSR versus Teleflex. They're pointing to all these secondary considerations that are really not all that persuasive in this context. The outcome should be that we reverse the trial court here. This is not really a factual issue at all. We should not be deferring to the jury. Obviousness is a legal question, not a factual question, and so should not be deferring to the jury's verdict. Now, the dissent is just a sort of venting of why he thinks the majority is wrong. It's not binding in any way, right? It's not authority that later courts have to follow. But if we think of precedent as a way of thinking about what's the court most likely to do with the next case at this boundary, a dissent provides some evidence on that issue. It provides at least some evidence of how one and the other judges that join the dissent view the issue. So you can tell, if you happen to get those judges on your panel, you can't tell your briefs because you file your briefs before you know who the judges are going to be that hear your appeal, but you can tailor your oral argument to be a little more in line with the views they express in their published opinion. And over time, right, either the Supreme Court may grant cert and adopt the dissent's position. We see that happen. We'll see that happen when we get to the patentable subject matter rules. So the dissent, although not binding at this point in time, remains an important decision, both because it may suggest how particular judges are likely to rule going forward, and it may eventually prevail later, sort of in-bank hearing in the Federal Circuit or the Supreme Court or Congress may come along and say, yeah, the dissent was right on this issue. So that's why the dissents are often included. They're always published and sometimes included in the case books because over time they may become the prevailing law, even if they aren't initially. Okay, so that is non-obviousness. So we start with a Graham three-part test. That is a way of framing up the question, right? How big, how significant are the differences over the prior art in the light of the ordinary skill in the art? And then we're sort of supposed to intuit whether this is a large advance and so needs that inducement of the patent, a small advance and so doesn't need that inducement of the patent. And if we're uncertain about that, we can look to the secondary considerations that the courts have identified to try and get a handle on whether sort of people struggle with solving this problem as long felt, strong pent-up demand. And so if it was really easy, it would have been solved sooner, or whether, on the other hand, it's sort of a trivial advance, lots of people solving it all at the same time, that sort of thing. And so that's non-obviousness. Next week, and this is the last, we'll get into utility and the sort of procedural hurdles, what you've got to include in your patent application. But non-obviousness historically was the principal hurdle to patentability. Now it's just one of several hurdles to patentability, but remains an important one.